purpose and overall scope. So in this, we will explain the primary objective of AI Act. The EU Artificial Intelligence is a comprehensive set of rules aimed at shaping the development and use of AI systems in Europe. It basically represents a decisive step towards fostering both innovation and trust in technology by striking a balance between protecting the public interest, security, and fundamental rights and support for the technology processes. So, a key objective of EU AI regulation is to ensure the smooth functioning of the internal market. This is achieved by introducing uniform rules for the development, placing on market the use of AI systems within the European Union, such as harmonized approach, which prevents the fragmentation of market through different national laws and promote the coherent application and compliance across national border. So another key element of the regulation is the promotion of human-centered and trustworthy AI. So which basically means that development and use of AI technology must be in line with the fundamental values and the rights which are upheld by the European Union. So these basically includes protecting personal data, ensuring the safety and health of citizens and protecting the democracy and rule of law. So as we see, the intent of putting this AI Act is to have the uniform rules for the development, marketplace, and use of AI system. And obviously, the intent is how you can ensure the AI systems are developed and used in line with the fundamental EU values. So, most important thing, uh, the primary objective of AI Act is how you can have a promotion of human-centered and trustworthy AI based on this act. So now let's understand the scope of AI Act. So if you see on the left-hand side, you basically see the scope of the AI regulations, and on the right-hand side, you will see the elements which are not in scope. So in scope, if you see the providers who place the AI model with a general purpose AI on the market. So the providers and deployers of AI systems, regardless of whether they are based in the EU or any third country, they need to provide the systems which are used in the EU or the rest or the result is used in the EU. Also, the product manufacturers who place the AI systems on the market or put them into the operations together with their own products under their own names or the trademark. The AI systems that are placed on the market, put into the service or used in the EU. So this basically applies to the providers, deployers, importers or distributors of AI systems. Your authorized representatives of providers who are not established in EU, and also the real world testing of AI systems that are otherwise used for research, testing, development activities because they interact with the natural person. So these are the elements which are considered as part of scope of AI regulation. So now let's talk and discuss about things which are not in scope. So the AI systems that are only used for the personal or non-commercial activities of individuals. So the AI systems used in area not covered by the union law, so regarding the national security, and the AI systems which are used exclusively for the military purposes or the national security. So the AI systems which are used for the sole purpose of research and development once they are developed or operated. So the AI systems for the research, testing, and development activity before they are placed on the market or put into the operations, except for the real world testing. So authorities in the third world countries and the international organizations provided that appropriate safeguard exists regarding the protection of these individuals. So these are the elements which are not part of the AI scope or AI Act. So now let's talk about the summary of Article 10 of AI Act. So if you see, the AI Act basically discusses how your data should be managed for the high risk AI systems that use the training techniques. So in this article, we basically look and discuss about the elements which are important from that perspective. So let's first look into the explanation of terms. So biases. So biases is basically a tendency to favor certain outcomes, which can basically leads to unfair treatment. So now let's talk about data governance. So data governance refers to managing data to make sure it is used properly and securely. High risk AI system. High risk AI system fundamentally means that they could significantly impact people's rights or safety. Pseudonymization. So it's like replacing the private data with any kind of fake identifier to protect the privacy. So these are the explanations which are put across for the terms which are used in the AI Act. Again, let's talk about special personal data. So the kind of category of personal data which requires some additional protection due to its sensitive nature. So we need to be extra cautious about that. So this includes the data which reveals the racial or ethnic origin, the political opinion, your religious or philosophical beliefs, your trade union membership, your genetic data, any kind of your biometric data for uniquely identifying a person, information on health, information pertaining to the data of a person's sex life or sexual orientation. So these are the category of special personal data. Also, let's talk about the training, validation, and testing data set. So these are the consent which are basically pertaining to the data used to teach the AI system, and they basically check their overall performance, and they also ensure how they work correctly. So the training, validation, and testing sets are used pertaining for teaching and modeling the AI system so that the overall performance can improve over a period of time. So now let's talk about the summary of Article 10 of AI Act. So these AI systems should be developed using some data sets that meet certain quality standards. So you need to first look into the kind of data governance. So data basically is used for training, validation, testing. The high-risk AI systems must be managed properly. So you need to ensure that the right decision choices are made. So you need to also make sure that you know how and where the data was collected, why the personal data was collected if applicable. So whenever you are making any choice of data collections, you should always avoid collecting any personal data. Processing the data correctly, such as labeling and cleaning it, is very important. Making and checking the assumptions about what data represent. So you always need to make sure the assumptions are done correctly. You need to assess that there is enough suitable data which is available, ensuring that the correctness and there should not be any kind of biases in the data. So we need to ensure that the data which is there might not harm people or violate anyone's right. So correctness of data is of utmost importance. Finding and fixing any kind of data problem that might prevent following these rules. So this is one of the view that how we can ensure that data governance can be managed.